started. Thank you everybody for joining me today. This is the first of the power of attorney. Last week I had done the health agreement sessions, and I may revisit that and do that again at the end of this series. But today we're doing powers of attorney. I am doing this in duplicate, so the next session that's offered on Tuesday, it's next week, is a duplicate of this, but I am speaking live. And so there is, I'm just going to move to here. Where do I get out of that? So how do I click there? I can't see it here. So, all right. So this is just a bit about me. So I'm Beverly Carter. I'm a notary public. Some of you know me and may know me well. And so I want to thank you for supporting this. I just have, my background is as a teacher. I worked in small business before I was a notary. Also worked in the executive government. I have many roles in life. There they are. Probably my favorite one these days is mother to my dog Sumo. So, and boss. I've got a great group here. And so I'm just going to introduce you to the group that I do have. So we have Vicky on the far left, and then Rachel, and then me, and Kayla, and that's my regular team. And we have a special member of our team for the summer. This is Alicia, and I'm just going to turn this so you can see Alicia. She's a business student in the Gustafson School at UVic, and she's here doing a marketing co-op placement for me, because there's always need to work on business. And so especially now is a good time. So a couple of housekeeping items. There is the chat option through at the bottom, and again, where does that go? I'd like it to stay up. It goes away when I do this. Anyhow, sorry, I'm just chatting. So so I can see the chat function. I do welcome questions throughout, or if you have something that you want me to touch on, or an experience or situation, I'm happy to take a look through that. I'll try and either answer it as I'm going through, or deal with it at the end, because I do have a Q&A session available then. And I'm just going to say that my friends who work in any real estate industry, real estate is still happening these days. So I've got a little bit of a shameless plug there. For the fact that we do real estate, and that the industry is still active, and we're still seeing deals come through. So wishing you all the best as well. And so if you enjoy this session, I'd ask that you share it with your friends or family, or on any Facebook community boards or groups that you're in. I would really appreciate that. And then, so this is just a bit of the background. This is probably a bit more about my approach to how I deal with my clients. One of my backgrounds, when I moved here 20 odd years ago, I couldn't get a job as a teacher, although that is what I'm trained in Ontario. And it helps me to deal with people to, people have different styles of thinking and doing. And so it helps me to take a step back and try to understand them and try to meet them and communicate in a way that works best for them. When I originally set up this session, I'd actually done this a number of times for the brain injury group. And so particularly there, you're dealing with people with a lot of different, one brain injury is not the same as the next. So it was really important to understand how I operate. And so a bit of that comes from that. But there are 4 main documents that we consider personal planning documents: your will, your power of attorney, your health representation agreements, and advance directive. And as a notary public, I am legislated to be able to do all of those. There is some exception around doing wills, and I'll talk about that in the wills, but essentially for about 75% of the people, we can manage their wills. Powers of attorney are interesting because they're not all the same. Health agreements, for those that tuned in, also will find that there are 2 different types of health agreements. And then advance directives are your own directions about your own health in advance of something happening. But today we're talking about powers of attorney. So the power of attorney is a document that allows you to appoint someone else to act on your behalf to deal with your financial and legal affairs. It does not allow for health or medical decisions. It is only financial and legal. And I want to qualify that because BC is unique in that we have two different laws. We have the Power of Attorney Act and we have the Representation Agreement Act. Under the Representation Agreement Act, we can do our appoint health representatives. Under the Power of Attorney Act, we appoint an attorney just for financial and legal. There are other jurisdictions, if you were to go to California, California has a power of attorney that embeds both elements into their document. Or Ontario, where you have powers of attorney, I think they call it for personal care. I was looking at one the other day, I just forget. So a lot of people really misunderstand powers of attorney. It's very common that I hear people saying, but I want this to be for my health, that it is just financial and legal. So there are three types of powers of attorneys. So you have a specific power of attorney, a general power of attorney, and an enduring power of attorney. Today, I'm mostly going to focus on an enduring and general, which is really the two of those put together. But specifics certainly have their place. I do them from time to time, and they are, for example, where I tend to do them mostly is when people need somebody to act for them for real estate. Common one would be, particularly in our town, where you have professors at the university who might be taking a different appointment somewhere in the southern US, Hawaii, somewhere, and they've gone for their job, and in often cases the spouse is also gone, and so they don't know when they're going to sell their house, and so they need somebody to step in and sign on their behalf. Or in some cases, I've had people who are dealing with maybe traveling, or they're dealing with other things, and they're just not certain what their schedule is going to be. So we'll set up a document to allow another person to sign off on their real estate document. So that's the most common one that I do if I'm going to do a specific. The other ones have been where somebody's traveling for a specific amount of time, maybe 6 months, and they just want to make sure they've got something in place for during that time, because they're not quite ready to do a general or an enduring one, which has a much longer time span. So you can do them for short-term, long-term, or other. There are also, under the specific category, you'll see banks actually have powers of attorney. So you may realize this if you had signing authority on your mom's bank account or Auntie Margaret's bank account. Something like that generally is a specific power of attorney just for the bank. So if you've done it at BMO, it's just for BMO. It's not for BMO Wealth Management. So I don't see those very often, but I have some because I have business accounts that I have other people who have the ability to sign on my business account, not my trust account. So I've got numerous specific ones myself, but my life's a little more complex that way. So a general power of attorney is typically for all purposes, right? It's not restrictive, it's not specific to a time frame or a specific use. But what you want is enduring, and this is the one question that I get most frequently is this an enduring power of attorney that we're doing? And generally what you have enduring, it means it endures through your loss of legal capacity. So in my world, legal capacity is like mental capacity, but what makes it legal are all the ticks in the boxes that I do. And so, for example, do you know what you own would be a tick in the box. Do you know what you owe would be another tick in the box. And so it endures through your loss of legal capacity, and that can be temporary. So you're knocked out for surgery. You go for surgery and you're okay 3 days later, but obviously when you're under an anesthetic, you have zero capacity. You're a little foggy on the other end, you have some capacity. And then when these things have worn out through your system, you're back to your regular self. I'm just going to let somebody else in. And so, where was I going to get rid of that? I have pop-ups that break my view. So enduring is the one that most people want and should have. And mental incapacity, like I said, is like legal incapacity. But we have different people doing different capacity tests. So I'm a notary, I do it from my perspective. You'll have a doctor who does it from their perspective, a social worker from their perspective, and so on. And so in order to prepare an enduring power of attorney, you also have to have full capacity. So this is, I'm just going to see, I'm going to get something out of my view here for a sec here. So this is the one that we're mostly talking about. And I've got some other pointers to make about this as we go through. Some of the reasons why a power of attorney is important is essentially, you know, the general rule of thumb is that if you have any assets, you should have a power of attorney. And most people have a bank account and a car. And, you know, the more assets you have, the more you really should have the document put in place. And it just allows you to be in charge of who you appoint, but allows someone to step in to help you if something sudden happens or unexpected. And the sudden and unexpected isn't always a catastrophic health event, although in my world, I see a lot of that. But I will often give the example when my son, he's now 27, but when he was 19, and he was traveling to try to break into the music industry in a different country, I thought, oh, I should just get him a document because just in case. And I thought, he doesn't own anything. And really, I never imagined I would need to use it. But being the practical mom that I am, I thought, let's just get it done. And honest to God, a week after he left, I needed to use it. And essentially what happened was that his wallet was stolen. So everything he had on him was stolen of value. And the saving grace was that he didn't have his passport on him. So he had that back where he was staying. But with ease, because we had done an enduring power of attorney and registered it with the bank, which was TD in this case, with ease, I was able to go to the bank, cancel his debit card, cancel his credit card, get new ones reissued. I was able to look at the account to make sure there wasn't any fraudulent transactions. And I was able to get them to flag it for any potential future issues. I was also able to get new credit card, new debit card, and new driver's license made. So it was an aha moment for me, because you can be 19 and it can be a valuable document. And most people tend to think of this as an older person's document, and you know, as we're aging, 80-year-old mom or whatever. But the reality is you should have it much, much earlier. The best scenario is that you have one and it collects dust. But when you need it, it's really a powerful document. And that's why I give the example of my son, because we tend not to think in circumstances like that. So just carrying on to see if I haven't covered anything. So here's something that a lot of people don't really think about, is if something sudden happens, and I tend to use the example of a stroke, because funnily enough, that is the one thing I tend to see the most of when I'm getting called in on an urgent basis. It's certainly pre-COVID to go see somebody at the hospital. That is usually the most frequent risk factor that people have is heart-related stroke, heart conditions. And so, you know, people do recover or get better, but for some time they may not be. And if you don't have somebody there to take over and manage your bills and make sure your assets are secured, things like your credit rating can be impacted. So again, the document should collect dust, but when you need it, it has a role in your life. Another one that comes up quite frequently, and more so I'm seeing this, I've seen a trend since about last summer, where a lot of people are bringing to my attention when you have a joint bank account and somebody is using a power of attorney, the it's not always easy to use with that. So sometimes you're identifying issues before they become an issue. The nature of a bank account for joint owner can be either or joint, and that distinction matters in my world, and in your world, and in the banking world. So these are questions that I now am getting people to get answered, because I don't want to prepare a power of attorney that somebody goes out to use, and their mom and dad have a joint bank account and they're not able to use it, but that's the main bank account. And so we don't want any issues, so we can plan for not having issues. In the absence of having a power of attorney and there is a loss, especially a permanent loss of a person's capacity, and there is no, you haven't done any of the estate planning, and documents aren't either up to date or done at all, your only option is to get a committee order. And a committee order is a court-appointed guardian. And the last one I talked to a lawyer about this in the last maybe 3 or 4 months ago, they estimated a minimum of $10,000 to $12,000 to get that done, and then easily 4 months of time. So nothing happens quickly when you're dealing with the financials. So here's some background. Who can make an enduring power of attorney? So you have to be 19 years old to do that, and you must have the capability to do it. And I talked about that earlier. So what you own, how do you value it, what obligations do you have to others, and that you need to understand that the person you're appointing will be dealing with your financial and legal affairs, and they basically can step in and do what you would do for yourself, but you can't. There are some legal exceptions. They cannot make a will for you using a power of attorney, so only you can ever do that, and you have to have full capacity for that. If somebody's not managing, so if, I'm just trying to think here. If somebody's not managing your assets, the potential for the value can decline. And we just have to think about the ride that we've taken recently in our markets to see how quickly something can change. So you want somebody who can responsibly step in and manage. You always have to be aware that somebody can misuse their authority. That can be because they just don't know, they're not really that qualified or that experienced in a particular area. Or it can be an abuse of power. And that the statistics are 90% of abuse comes from family members. So think about that. I'm sure you all have heard or know somebody who's been subject to some form of abuse with a power of attorney. They're out there, they're real. It is something that I do as a professional. We are constantly on the lookout for any undue influence, no matter what document we do, no matter how, if it's a simple signature for somebody doing something in the US, or when we're making our wills or powers of attorney. So this is part of the value of having any professional prepare documents for you. It's our professional obligation to make sure we're looking out for you. And to always know that you can revoke a power of attorney. I've got that noted elsewhere. I'm going to touch point on this a little bit more. But here's an example of what the beginning of my powers of attorney look like. And when I do the powers of attorney, I have, mine are actually more detailed. In reality, you can do a power of attorney that's probably 2 pages that grants all authority. And certainly powers of attorney in the past, that was the standard. They were very short and to the point. And in previous legislative terms, in some cases, even the attorney did not know that they were appointed. They didn't have to sign for it. In today's terms, under our law, we do have, the attorneys have to sign for them. But you'll see I've appointed Donald Duck there as my husband. I'm sure somebody's laughing out there about that. Don't tell him I said that. But thinking in terms of who you appoint is probably the biggest consideration. I mentioned that family are known to be 90% of the abusers. if there is abuse that's going to happen. It's not 90% on all powers of attorney. It's just if it is going to happen, the odds are it's going to be a family member. But I strongly urge people to consider the qualities of the people that they appoint. What time are we at? Can you just go in there? So I'm just making sure I'm on time and not going over for you, because I respect your time. And okay. So the qualities, is the person that you're appointing a person of trust. So obviously, if you have a spouse, that is usually your obvious person. But I say that with caution, because the definition of spouse these days includes a common law spouse. So I've met with people recently who've just literally moved in with somebody else and said, "This is my spouse." Well, in my world, a spouse is a person that you've been living with in a common law relationship for at least 2 years, or you are legally married. And so, I find I deal with a lot of blended families who may have a good relationship, but they also have obligations not only to their spouse, but to their children from previous relationships. And so, you can build in elements to who you trust. And sometimes you don't want to give all your power to that other person. I'm not saying don't trust your spouse, for sure. I trust mine, but just to know that you have options in who you appoint, but the qualities that they have should be, are they good with their own paperwork, right? Are they responsible generally in their own lives, which is a good indicator that they'll probably be responsible in your life as well. Are they local? Do they live in, I don't know, India or Australia or England? In some cases, that's the only person or the only second person that people will have. So, and they don't have anybody else locally. So it's better to have somebody than nobody. But those are factors, but that impacts their availability as well. And availability can be, do you have one of your kids who's actively raising triplets? Her availability is probably not so, or his is probably not that great at this time. If you have more than one person, are they able to collaborate and work together? And do they understand their duties? So the very first point of the duties that's built into the law is to act honestly and in good faith. And I build these duties into my documents because I believe the ethical role, which is embedded into the law, is lost by some people. And I always say that there's two reasons that these people should act. One is you are asked to act, and the other one is it's obvious you need to act. And those things are clear. The obvious to act is somebody's had a massive stroke, you should be on it and make sure that their house, their car are protected, their mail coming in, those sorts of things, right? But then there's the not so obvious. So you have, and this was an experience that I had, my mom had Alzheimer's. And in the beginning, she could manage things, but there does come a point where they can be subject to abuse by others or influenced by others, or they can do harm to themselves, right? They don't know the difference between, one thing and the next. And an example I give is a friend of mine whose aunt had been left a little too long to do and manage her own affairs with dementia, had paid out a total of over $200,000 on 3 different payments on a credit card, but didn't have the cognitive awareness to realize that, hey, I shouldn't be paying $70,000 on this credit card. So cases like that, you need to step in and protect others. And it starts somewhere. And sometimes, dementia is none of us have the crystal ball as to whether or not we're going to be the ones that have it or our loved ones. So you need to be vigilant if you suspect it, because you just need to protect them from themselves sometimes. You can also consider an appointment of a professional, so like myself, but I don't say notaries only, but if you have a good relationship with your accountant, there's certainly a person worthy of having the conversation with. In some cases, just to give an example, I am appointed along with one or two other people, and I give the caveat that yes, I'm here because I'm a second set of eyes, but I'm also here as your backup. You should really have your friends or your family managing this, but if for some reason they're away, or I get some suspicion that there may be some misuse, then I'm there as the professional. I have some very stringent rules and regulations that apply to my actions, and I take that very seriously. So it's a reason to consider a person who's a professional. And yes, you can appoint more than one attorney. I'm quite a fan of more than one attorney. One is better than none, of course, but if you have one, you're only relying on one. And if I come across where some people will appoint a spouse because they don't trust any of their kids, or they don't have kids, or some blend of that, or they're not available. They're living in England or somewhere, and so that's better than none. But you always need to be aware that if you're appointing one, there's a risk if that one person can't continue to act on your behalf. Or the other advice I give to people is that if you have the crystal ball and you have a health diagnosis or extreme advanced age, these are things that are reasons to update your power of attorney, and then maybe you look to somebody professional to do the job. So multiple attorneys are possible. I think I've done as many as 5 in a document. I don't recommend that. I didn't recommend it in that case, and I told my clients why. But you can, a typical one with a couple or a couple will name a spouse primary, their kids as alternates, or one kid first alternate and then the other one the second alternate. That's a common scenario, but you can really blend that up. In some cases, and I use the couples because most of us probably get that, and we came from parents, so couples will give each other all powers, but then when they're naming, say there's 2 kids that they're naming, those kids can act either or. But in some cases, I build in a restrictive element to the document where they have to act jointly if they're selling a house, dealing with an investment over $10,000, transferring anything into their own names. There's other ones, but those are the types of things that when I talk with my clients, I get them to consider as options. I'm generally a fan of that because I am aware of the potential for abuse out there. And in some cases, you just don't know who that's going to be until they're appointed. But I think you can make some pretty educated guesses about who is good. You've raised your own kids, you know them the best. Or your sibling, you grew up with them, you know them the best. And so these are very practical conversations that I tend to have with people about the appointments of people that they make. I talk a bit about some of the details that you see in the power of attorney, only because I talked earlier how you can have, technically, you can have a 1 or 2 page power of attorney that's good, gives all powers to the attorney to be able to do everything you could do yourself. But in reality, there is the practical use of the document where we are starting to see more and more issues around the use of the document. So an example would be if you have a safety deposit box. And if you have an existing power of attorney yourself, you might find that there is a clause in there that allows the attorney to access any safety deposit box that I own. Let's be clear, there is nowhere in the Power of Attorney Act that says you have to state in the document that you're giving the power to access a particular asset, like a safety deposit box. But the banks have consistently and this is quite some time for this particular asset, have made it very difficult for using a power of attorney for the attorney to get into a safety deposit box and access it and deal with contents therein, either put something in, take something out, or whatever. Technically, they have the right to do that, but the reality is that institutions have started to become more cautious about the use of the power of attorney for good reason. So these are the types of things that you'll see. Other examples that I embed into my document are, and it's not more power, it's just clarifying the powers, would be, for example, for use out of jurisdiction. So maybe you have a Mexico timeshare and you want your attorney needs to deal with that. So, but that's out of jurisdiction. In some cases, you might own the timeshare in Mexico, but it's dealt with a US-based thing. So it can be quite complicated, and something as simple as that. So we build in things like that. There are a number of other ones that I put in, and it will depend the ability to distribute your assets if you can no longer manage them, or to restrict from doing that in some cases. To distribute personal items if you can no longer live in your own home, and those sorts of things. So a lot of those are done just in the context of each person. A lot of people have variables in their lives. There's a lot of commonality, but there's a lot of variables, and so I will put in into the document clauses that are intended to help you. So not all powers of attorney are created the same, but just to know that you have options. And I think that's the thing I really want to impress on you, is that you have options. And that in doing a power of attorney, one of the common reasons that I hear for people not doing them is that, you know, they don't trust anybody, right? And, you know, there are ways to build into the document control. Like I said, you can have two people having to act jointly to deal with a major asset, like selling a house. Those are control mechanisms, and in my mind, those are good. In some cases, they don't make sense, right? Because some cases you may not want that, or your level of trust and the people that you're appointing, you know their ethics and you know them well, and you know that they would do the right thing. That's good too. But the document is always yours to own and control. So when a power of attorney document is drafted up and signed, it's a powerful document. You want to keep it safe and secure. My practice is always to do 2 originals. And I do that purposely because there's always the potential that when an attorney is using the document, they accidentally send it away. So, for example, they're talking to Sue at in the Saskatchewan Pension Corporation, let's say, and Sue says, "Oh well, you know, you the attorney, I need proof that you can act and that I can deal with you. So please send me the original." A lot of people have been trained to be asked for the original, which is accurate. But the reality is, when you're dealing with a lot of these things at a distance, you can send in a notarial certified copy. I do too, because you got one as a backup. So there's all, and I know from using my own, in the case of my mother, and this is one of the places where I really learned how restrictive it is if you've only got one. My brother and I, one of my brothers and I, we were appointed for my mom after my dad had his accident. And either of us could act, but he lived in Kamloops, and he's the older brother, so, you know, he kind of had a thing where he wanted to keep the original, and I'm like, whatever. But in reality, I did most of the work, and I found in trying to use the document that I had a lot of stumbling blocks because I didn't hold the original. I only held a notarial certified copy, but I was able to talk my way through. My experience is that banks and different institutions are becoming more and more cautious around the documents, so it's getting harder and harder to use them. So I have 2, so you've got one as a backup, or if you have 2 attorneys, they can each have one, in which case you still have one as a backup. Or you can hold them until you feel there's a need to use them. So if you had, I don't know, if you had the crystal ball, you had a health diagnosis of Parkinson's disease, which is kind of long-term, but, you know, ultimately ends with you with reduced capacity. If you found that, you know, you're a few years into it and you're starting to lose your physical ability to go out and do things, that might be a time where you say to your attorney, I'm going to give you the original. Now you can take this and now you can use it. but it is yours to own and control. And that's another thing that, and you can always revoke it if you don't like who you've appointed or they are no longer appropriate. As long as you have mental capacity, you can do that. You can update them. Here's where I want a little audience participation. So in your mind, what do you think are some of the pros? We're just going to start with the pros on this. In your mind, just in your chat, wherever the chat thing is, let me find it. Just type in, what do you think some of the pros are? I'm curious to see what you feel is the value of the document. And everyone in the meeting, okay. Right, thank you. Yeah, so we have one here, peace of mind, less stress for your loved ones. Yeah. Yes, thank you. It saves having the family to try to figure things out. Absolutely a pro. Right, you've got somebody there, so you've got somebody appointed either if you're out of country or you become unable to make your own decisions. True, you don't. A big one is you don't leave it too late, so you're not having to get a committee order. And as I mentioned earlier, the committee order is very expensive and time consuming and stressful, right? Better to have one than not. Yes. So true. Yeah, I would say you've got the ability for somebody to step in and take over things when you can't do it yourself, and that's the biggest reason. And it is peace of mind. I chatted to one widow whose spouse was diagnosed with early onset dementia at late 40s. And she said, I don't know what made me do it, but we had just gone and got a power of attorney done with a lawyer. And she said, honestly, the diagnosis came about 3 months later. And within a year of that time, by the time he turned 50, he was fully incapacitated. It was just that aggressive. I've certainly seen that with some people. I also see, and I talk about dementia or Alzheimer's because that's, we've got this huge silver tsunami happening and none of us actually know if that's going to be us or not. And so I think it's important to be prepared. There was, I was just going to touch on a couple of other points. So let's talk about the cons, because I think I'll bring up these other points after what are the cons of having, or what are the cons or maybe your concerns about having a power of attorney? Anybody? No concerns? Oh my gosh, you're all, yeah, okay, that's good. Right, so a con is, yeah, the difficulty in which one of my kids to choose. I've had recent clients who've had multiple kids who are really having a hard time with that. And the reality is, if you have too many cooks in the kitchen, that's not a good thing. I think you can, if you can't make a decision, then you should really consider appointing somebody who does this, like a professional. Because too many cooks in the kitchen, you may set them up for failure or for issues. I am a fan of at least two, if you're appointing a spouse as a primary and then kids as alternate, at least two. But you could look to other family members as to who to choose. Maybe you can have somebody work with them. I know a lot of clients will go back and talk to their own kids, and if the kids can't figure it out with the family discussion, they really struggle with that. I see that another a concern here is the opportunity to take you for a ride. Yeah, I'm a big, you know what, I am probably the biggest advocate for being safe with our powers of attorney. I have a zero tolerance for abuse. I'm aware that it's out there. I've seen it firsthand in people. I hear it from many clients who say, I would never have imagined my sister would have done that. Last person I ever would have expected. So some of the some of the risk factors, let's talk about risk factors of people. Don't appoint somebody who doesn't do their own finances well. Don't appoint somebody who, you know, where money is, you know, they're hypersensitive to money issues, good or bad. Somebody who's barely getting by, not a good person to appoint. You know, there are built into the law that if somebody is, if they declare bankruptcy, they're automatically terminated as a point of law. But the reality, if they had the document, they could still continue to use it. You know, I talk about how you protect yourself is you keep the document. You can build in some components where you have people restricted from doing certain things. In some case, you need to have them be able to do certain things because that might be best for you. But if you want to build in a restrictive, then I'm a fan of having two people where they have to act joint on certain types of transactions, like selling a house. That's a common one that we see. And that way you don't have one person sort of letting the power go to their head and they go off on a tangent. The other part of the reason for two, and this is from my observations in a lot of people and conversations, is that sometimes if there's one, that person isn't very good at communicating. And, you know, I'll hear this often from nieces, nephews, siblings saying, oh, all of a sudden my cousin now, they were appointed for my uncle and now they've got a new house, a new car, and there isn't anything else to suggest that they've got issues. If you know of anybody who is being abused, there are some routes that you can take. There are some a local community group that deals specifically with this. They're not well known, and I'd have to dig up their number, but they are here if you have concerns. If you know somebody is seeing their doctor, you can make a comment to the doctor. They won't talk to you, but you can give information to other people. And of course, there's always the public guardian and trustee, which is overworked and hard to get in touch with and to get action from. So, but there are some tools out there and peoples and organizations. I was going to talk to, there's also just another option out there. I know that the BC government provides a template for a do-it-yourself power of attorney. And I'm going to say, I get people coming in here asking me to sign them. First of all, I will never sign those because I need to make sure that if I'm putting my stamp to anything, that I've vetted that person. And a power of attorney, because I don't know if a person has access to $2 million or $2, that I need to make sure that that the capacity is assessed, that I understand the context in which this is being done, the purposes, that there's no undue influence. And so, you know, the do-it-yourself powers of attorney essentially won't be useful at any bank. They won't accept them because for all those reasons. They just aren't prepared to take the risk. You know, and there's very, very few instances. Maybe the Public Health Authority might be the one and only place that would accept it because they'll accept anything. For, you know, essentially for power of attorney, if you have somebody going in for healthcare and they need full-time care and they're then being carried into under the government system for that care, often a power of attorney will be used to sign over up to 80% of their income, like a pension, a regular pension, back over to the government to pay for that care. So if a person only has income of $1,000, they're signing off 800 of it. But if they have 10,000, they're signing off 8,000 of it. So it's just depends. And I think that's it for the pros and cons. Here's just, if you were planning to go ahead and do this with a professional, so, you know, you always need to start with your basic legal name. And frankly, 50% of the people I deal with, if not more than that, all have different versions of their name. So maybe you have married Margaret Smith that goes by Margaret or Maggie. Lots of people use middle names. Lots of people have, like me, Bev, my legal name is Beverly. There are different versions of names. So these are things that matter in the use of the document. You know, you need to know what you own, because, you know, in some cases when I'm assessing somebody, if literally they're living on a $2,000 a month pension and they own nothing else, their risk factor is very low for abuse because there's not a lot there to abuse. But if they had, you know, $2 million and, you know, 400,000 in cash, just easily accessible, different risk factor, right? So what do you own? Those are the types of things that I look at and review. There's also the different ways that you own assets. So you can own things jointly. You can own like RSPs, where you've got direct beneficiaries. You know, your power of attorney may need to have to manage some of these assets, but you don't necessarily want them changing the beneficiaries. I don't think that's easy for any institutions to accept, but in historically, it has been possible to do. So you want to make sure that I understand what it is that you have, how you want the attorney to use it, and what possible assets and debts will they have to manage. Again, what are your debts? What types of things? Anything else? And here's just a list of things that people might need to step in and manage, because somebody's had a stroke, right? Bank accounts, investments, income tax, mortgage, rent, I don't know, you name it, utilities, your home phone, your cell phone, your internet, right? Because expenses still carry on. In some cases, they can be managed. Or gosh, whatever. Insurance is a big one. Making sure, because if insurance is a large part of your estate gifting, you want to make sure somebody continues to make sure that your monthly $200 payment towards keeping that insurance up to date is done. And that's a lot. People don't tend to think about these types of things. These could have a real downside if you don't have somebody to step in and manage your various financial payments. Online accounts, I mean, there's a whole, I mean, that's just scratching the surface. And that kind of leads me into I had set up, and I touched on it at the very beginning, but put together a workbook that I found both in my personal life, when I've acted for people as their attorney, or had to step into somebody to become as their executor. All of a sudden, you're it. You have to manage a whole lot of information and details about that person on short notice, and it is a challenge. So I had put together this workbook that really blends those different perspectives of stepping into your electronic self, right? Because who gets statements anymore in the mail? Not many. Most of what we receive is online. You know, how are we going to know where? How are we going to know where to access? What is your account number that make sure that we can pay? Where do you know? I need to know what accounts I need to redirect mail to if you need to start accepting mail on their behalf. So that's just touching on it. So I think I've done my bit to say you should have a power of attorney. So thank you all. So I will respond to anything, or you can call into the office if you have some other questions. But I really appreciate your input and your listening and your participation. So thanks very much. Have a great week. Stay safe, and as I plan to be. Thanks a lot. Bye for now.